Thank you all for joining. It took a while. I'm sorry, it's starting a bit late. There was another earlier session that started later, so that's why the team took a bit of time to start this session. But again, thank you all for joining. Very happy to be here this evening. Always get so excited to speak to fellow entrepreneurs and startup founders. So there's a Q&A section on the right side of your Meet. Feel free to drop a note, just share about what venture or project that you're working right now. If maybe you're still working somewhere, you just got an idea, you're thinking about an idea, feel free to drop a note in the chat. I will read to hear what you're working on right now. I've got approximately 30 minutes, 40 minutes just to share some thoughts about the topic regarding partnership and agreement. Obviously, it's a very big topic. But before that, forgot to introduce myself. My name is Izwan. I'm based in Kuala Lumpur. I work a lot with technology companies and startup. These are the areas that I work a lot with. So very happy to be with all of you today. We have 12 people with us. So thank you for joining this workshop. Let's just get started so that hopefully more people will join as we move along. What are the goals of this evening's discussion or this workshop? We want to look at the basic elements of a valid contract. We won't go to the details because I don't, unless you're planning to become a lawyer someday, but we just want to look at what are the things that you should be looking at if you're an early stage entrepreneur. What are the common legal issues that you should be looking at when it comes to a contract? What are the legal issues and how do you spot legal issues and when you should care about a particular issue? So just a bit about me. I've been in the startup space for the last 3-4 years. Very excited to be in this growing ecosystem. Very excited to be here this evening with all of you virtually, unfortunately, but hopefully we can have this another physical section next year. We don't know. So I've been a lawyer for the last 10 years, but recently I've started my own law firm, focusing primarily in advising founders, people like yourself, somebody who may just have an idea, wants to start a business, a technology startup. Those are the group of people that we work a lot with. We will also work with venture funds, venture capitals in investment work, also with the accelerators and a wide range of guys that we work in the ecosystem. Something that I just want to share, this year, I've started a legal blog. So we've been sharing a lot of tips. Hopefully in the next few months, we will start sharing legal templates and contract as well, just so that you can see. A lot of people heard about investment term sheet, but we do not know how does the investment term sheet look like. So hopefully this kind of sharing that we're doing will be able to help you understand so that you get familiarized with investment term sheet. Someday when you got an offer of venture capital, at least you will know what are the usual commercial terms that you should have in an investment term sheet. In the blog that we've started, we'll also share the common legal issues about fundraising, about compliance, dealing with investors, dealing with startup advisors, employees. What are the things to look at when you do your first seed round and so on. So feel free to subscribe. Everything is free. We're not charging anything. And also next week, if you're free, join us for a free webinar. We'll be doing a discussion about investment term sheet. A lot of people have asked in the previous webinar that I've hosted about what are the things that they should be looking at. So we'll be covering about the term sheet, as to when is the term sheet is being used in an investment round, what are the usual terminologies in terms of the commercial terms that you usually found in a term sheet, what are the things that you can find in the terms of the clauses, what are the things that usually investors include in a term sheet, and what are the things that you should be looking at when it comes to negotiation. Because in my experience, I know a lot of founders, they get very excited when they get an investor that wants to put in money in their business. So it's also very common that a lot of founders, especially first-time entrepreneur, that would just completely excited and would just sign the term sheet right away. We really don't encourage you to do that, which is why you should get a lawyer that is experienced, whoever that lawyer might be, that you know, or someone that has worked with someone that is an experienced lawyer to help you go through the term sheet document. So feel free to sign up on PTIX. The link is down here, termsheet101.ptix.com. So hopefully to see you in this webinar next week as well. So let's get started. I've got approximately 30 minutes, like what I mentioned to you earlier, but I just want to go back to the usual basics in terms of when we speak about technology company, what do we mean by that? Essentially, in my personal opinion, there are three things that makes a technology company a technology company. First, you have the technology, obviously. What are the technology that you have developed? It could be an online website, online platform. It could be a mobile app. It could be a SaaS solution that you've developed. The source code that is underlying the algorithm that helps insurance companies save money on underwriting, or also maybe make more money, revenue for business and so on, depending on whether you're B2B, B2C. And also another thing that you should also look at is the people, because obviously if you're a venture capital looking to invest in a company, you have a great product, you have a great solution, but you don't have a good team, a management team, or what people say a dream team, it still wouldn't work. So the last but not least, obviously the capital, in terms of how do you want to make how exactly going to source for capital for your business, either by selling shares in your company by way of equity issuance or financing, or either taking up loan from VCs or other investors for that matter. So the point that why this I just want to put it out there is because each area is interconnected, so there are actual laws involved, like technology. Obviously, we're talking about intellectual property, we're talking about source code, the copyright, obviously in terms of who owns the ownership, whether it's proprietary, whether it's something that you are using from a public domain in terms of open source, for example. And the people, obviously, whether or not you are engaging the employee or the managed staff as a full-time, as a part-time, whether the person is getting a salary, or whether the person is getting a fee or sweat equity. And these are all things that will be captured in a legal contract or an agreement. So if you don't have things in writing, obviously you're putting yourself in a very situation where it creates a lot of doubts and ambiguity, and and that's what we'll be looking at in the discussion shortly. So happy to hear any question that you have. Just put it out in the chat or the Q&A, and hopefully we can address that later as we progress in the discussion. So let's take a quick look at what is a contract. Based on the people that are listening to this workshop right now, I don't know whether some of you are medically trained, but when it comes to contract, there are essentially five things that makes a contract a valid contract. So first, there must be an intention for you to have the legal contract. So if somebody and you never actually promised and it was not in writing, then obviously there could be an ambiguity as to whether or not there is actually such an intention. So, and the second, the third are quite straightforward. If I'm offering to sell you a car, there must be an acceptance on your part as the buyer to purchase my car, for example. And number four, I can't sell something that I don't actually own. I need to have some element of certainty in terms of the contract that I want to sell. So I sell something that I don't have, for example. Number five, obviously, consideration is also a very important component. There must be a value to the transaction. There must be an exchange, whether it's cash, whether it's non-cash, for example. If I do ABC, then I will get Y amount of shares in your company, for example. That could be an example as well. So I won't go through much detail why you need to have a contract. Obviously, having a contract in writing puts a very good command that you're actually putting out very clearly as to the expectation, as to what is it exactly that you are promising the other party. I also think that in this part of region in Asia, for example, putting things writing is something that is common, because I think a lot of trust, or a lot of people say is gentleman agreement and so on, which obviously is just gonna be a recipe for disaster. Essentially, why you should have things in writing is to minimize potential conflicts and mitigate problems. A lot of my time is actually spent trying to found this dispute. I see this happening all the time. I'm sure you may have come across in your own experience as well. Your friend and your two of your friends come together and started a company, and 3 months later, one of the friends who became a co-founder decides to leave the company and doing something else, and obviously that leaves another guy in limbo and so on. So if you don't have things in writing, it could be very challenging for you to get back the shares, find another person to replace the other guy that decided to leave the company and so on. And also, obviously, the other points that we will go through shortly is to protect your intellectual property, to make sure that you get paid. If you're doing a SaaS platform, obviously the subscription, there's a fee component there to make sure that every month you deduct the payment from the customer, whether it's monthly, biannually, or yearly for that matter. And obviously, in the end of the day, why you should have a contract is that you want to sleep well at night and have a trust, to build the trust and give you a peace of mind. So let's go through some of the quick questions, or the quick common question that people like to ask about contract, because I think it's also very important. First is, if you sign a contract, do you need to stamp the contract before it is valid? The quick answer is no. In other words, a contract is still valid even if you don't go and stamp it. In Malaysia, for in Malaysia, so just one thing to take note is that, even though you don't stamp the agreement, if there is a dispute, obviously, if you want to bring the document to the court, then the agreement needs to be stamped. So in other words, there is a severe penalty that you need to pay, because you have not you have not stamped the agreement when you're supposed to do so. So although the law says that the agreement is still valid even if it's not stamped, but if there is the dispute that you want to bring to the court, then the court will only admit the agreement after it has been stamped. So it's not a deal breaker per se, but just something to take note. So yeah, we were talking about the common questions earlier. Can we also use e-signature? The answer is yes. You can use DocuSign, you can use HelloSign, and all the other different e-signature providers out there. Most of the agreements nowadays have been e-signature. We don't realize that board and shareholders resolution can be signed electronically as well. So if you have a company secretary that tells you that they don't want to accept they don't want to accept e-signature, my quick advice to you is you may want to change your company secretary. I don't know, but most of documents now can be signed electronically, so it's not a problem there. Just that there are certain few documents that are still requiring you to sign using a wet signature, which is a physical signature, which is the annual account, which is audited account. You want to transfer shares, you still need to sign using wet signature. You're going to sign a trust agreement, power of attorney, and obviously court documents like affidavit and so on. Okay, also binding versus non-binding contract. When is a contract binding? When is a contract not binding? Again, we spoke earlier about the elements of a contract. It's going to rain in my house. Anyway, so let's just keep on going on. Agreement is valid so long as it fulfills all the legal requirements. We mentioned it earlier. Again, before that, feel free to drop a note. I'll send you my email shortly. Just send me a note on LinkedIn, or just drop me a note via email. Happy to share the slides with you. Just look at it as more of a high level overview or summary that you should be looking at. And obviously, if we don't have time to cover a specific question that you may have, feel free to drop a note on my email, and we can have a separate chat in terms of what specific issue that you have. So let's just very quickly go on to the discussion again. So generally speaking, a contract will be binding if there is an intention for the parties to make it binding. So a very clear-cut example would be if you put very clearly on top of the term sheet, for example, is an investment term sheet or an acquisition. If it says something along the lines of subject to contract, or subject to formal agreement, usually it means that the contract is not binding. So that's something we need to take note. So there are situations where even an investment term sheet, a 2-3 pager, could be binding depending on whether or not the parties intend for the agreement to be binding. So that's something that you should look at it carefully. So When you should have a binding contract? Yes, the quick answer would be if you're serious about a particular agreement. If you want to sell a company and you want the other guy, the buyer, to buy a company, then obviously you want the deal to be binding. You want the contract to be signed so that you can secure necessary commitment and make sure you get paid from the buyer, obviously. So generally speaking, most of MOU or memorandum of understanding are non-binding. So because it is generally non-binding, it also means that it may reduce the chances for you to get the other party to commit on the commercial terms that you want. So if you're really serious about a particular deal or transaction, you should have the agreement to be binding in nature. So we won't go too much detail on the point, which is boilerplate clauses. Just take note that boilerplate clauses are essentially the usual commercial things that can be found in an agreement. You can find a lot of these examples on the internet. But just take note that one thing I wanted to highlight here is that there's really no such thing as a standard contract. So if the investor tells you that everything is standard, everything is common, I think there should be a red flag there. Every contract will have different terms. I would like to say hidden provisions. So some sneaky people, I don't know, I'm not suggesting anything, but it's good to have someone to take a look at the agreement. You need to go through the agreement line by line to make sure there's nothing unusual in the contract. I can just share a quick story. Recently, I reviewed a non-disclosure agreement, NDA. I'm sure it's quite a straightforward document. And when I was going through the agreement, both of the parties in the agreement that signed the NDA are Malaysian companies. But as you go the down further in the clauses, you realize that under the governing law, which is a clause that talks about which particular law that will govern the contract between the parties, and I saw that it's actually New York law. So summarize, I think one of the parties would have taken the template from the internet or something like that. It's quite unfortunate that none of the parties picked that up, which means that perhaps none of the two parties actually read the contract. So that's something to take note when it comes to agreement, obviously, to know that there's no such thing as a standard contract. So these are some of the example that you should take note. Again, happy to share the deck with you. Just drop me a note or email, and I'll send you the deck link. So very quickly, because the topic that I'm supposed to cover is quite broad, very quickly talking about common dilemma on founders equity. We won't go through details here, but the usual thing that we realize is that a lot of founders don't have any agreement in place. So a lot of things are very verbal in nature. So it's like um, my friend or my co-founder is going to give me 30% or 40%, but that's never done in writing. It creates a lot of friction, which bound to happen, especially if you're starting out a business. You do not know each other very well. It's more of a marriage of convenience, which is why it's important to put things in writing. If you promise a percentage in a company, make sure to put that in writing. And even so, putting percentage can also be quite challenging because the value of the company would generally go up in the next 6 months, 12 months as the company goes for fundraising and so on. So what I'm trying to say in this slide is that you should have things in writing. It can be a 1 or 2 pager. It doesn't have to be 30, 40 pages long at the initial stage, just so that people are clear in terms of what are the commitments and what are the obligations by other co-founder. I've seen this happening too many times. If you don't have the things in writing, a lot of this happens. You have two co-founders that started a company together. You spend money paying company secretary to set up the company. 6 months later, one co-founder decides to throw in the towel, say, I can't do this anymore. I gotta take care of my family, or something happened in his life. He just decided to leave the venture and start and join take up another role in another company, for example. It puts you in a bind. So if the relationship is still amicable, that's fine. But if there's a dispute, you may end up in a scenario that you may even lose the company. You're stuck because probably you decide to give the other 50%. You have another 50%. You can't do anything because there's a deadlock, and the fact that you don't have things in writing actually complicates things. You may end up having to leave the company or transfer or surrender the shares to other guy and just leave and start a new company. And obviously, it's going to be very time consuming, and from an opportunity cost perspective, you will lose time and obviously the resources that you have spent on that previous outfit that you've done. So very quickly, these are some of the aspects of why you should have things in writing when it comes to managing a team. First is obviously employment law. You want to make sure that you comply with the employment law. If you want to classify someone as an employee, I know a lot of early entrepreneurs may not want to hire somebody full time, so they rather hire the person as a consultant or as a contractor where it gets paid a fee or even the sweat equity. It's important for you to put things in writing, and I know a lot of early stage founders out there wants to save money. They will even go to the extent of offering internship and not putting things writing. But when you hire interns and you tell the interns to come to work from 9 to 6, and you pay them small amount of money, or some don't even pay anything, they're just giving them experience. It's going to be very challenging if the intern actually goes and make a report, because currently there is no law that defines who's an internship. But if you treat the intern that the intern is an employee, the intern could actually make a report to the regulators like the employee provident fund, and say that you have not been paying him and so on. So obviously you don't want to be stuck in this kind of scenario. So if you don't want to pay EPF and social security and so on, make sure that the agreement is not an employment agreement, it's a service agreement, and there are implications in place. Why it's also important to have an agreement is obviously when it comes to intellectual property, and how do you manage confidentiality. So in a lot of scenarios, people like me, for example, who may know a particular subject matter in terms of legal, or somebody has an expertise in a particular area, and may not have the expertise in coding or programming. So I may want to hire a programmer or coder to develop the app or the website for me. So what happens then is that, how do I make sure that the ownership of the source code or ownership of the content belongs to the company? Is actually through a contract. It's called assignment agreement. And how do I make sure that all the things I'm disclosing to the other partner or the other party doesn't get disclosed to a third party, is by way of NDA. So these are all the reason why you should have contract in writing, so that everybody is on the same page. Last but not least, obviously, is compensation. When you're starting a company, you may not have a lot of cash, or you're bootstrapping using your own savings, so it may not make sense for you to spend a significant portion paying your for example. So you may want to offer them a sweat equity, which is a percentage or shares in the company. You can do so by setting up by giving an offer letter, putting up the amount that you're offering and the shares that you're allocating, for example. And all this thing needs to be in writing, so that there'll be no misunderstanding, and when exactly the shares will be issued and exercised by the early stage the team that you have in your company. So that's something to take note. What to have in your contract? Obviously, different contract will have different usual commercial terms, but these are essentially some of the things that you should be looking at. There's usually four things. The first is obviously intellectual property, a very crucial component. You want to define the intellectual property. If you have a vendor, you have a customer, you have a B2B, or somebody that wants to white label your SaaS platform, they want to use their own brand and say it belongs to them as far as their customers are concerned. So you may want to put it very clearly in the licensing, so that you make sure that the ownership of the IP still belongs to you and so on. And it also raises a big question about data, for example. What happens to the data that is being collected, that is being processed? So this is why things in writing is very crucial. And also other things that you want to look at is to define the expectation that you have with the other party. We don't have much time, but just go and Google this case between Xiaomi and Mobvoi. Is about a dispute. So what happened was 6 months. Um, um, there was an oral agreement. Nothing was done in writing. So Mobvoi was supposed to is an AI company in China that was giving their technology expertise to Xiaomi build a smart TV. So 6 months later, when they were ready to launch, the next day before the launch day, Xiaomi signed a long contract for the AI company to sign. And obviously, the contracts were all lopsided and so on, and they didn't sign it, so it became a dispute. The point I'm trying to make is even large company like Xiaomi does this kind of stuff. So you want to make sure that you have things in writing so that you're clear in terms of who owns what and so on. The other two are interrelated. Obviously, you want to limit your liability. If you're offering a particular service in the healthcare space, you want to make sure that you want to limit your liability on certain area, indemnity, and so on. And the last but not least is termination. And there's always this thing that lawyers like. A good lawyer is someone that finds an exit clause to make sure that his client doesn't have to go to the court and so on. But obviously, that's something that all the corporate lawyers try to do, is to think what will be the exit strategy for my client in case the deal doesn't go through, in case the transaction gets aborted. What are the sequences at a different point of relation? If you start a customer contract today, 1 week later you don't really like the way how the other party is doing things, how do you terminate and what are the implications? So these are the things that you need to look at. And obviously, after the contract is terminated, what happens to the IP right and so on? So that's something that you need to take note when it comes to contract. So again, objective and purpose is very important for you to clearly understand why you're having things in writing. A lot of early stage entrepreneur likes to use a lot of fluff word instead of being specific. They like to use a very generic wording, which is something that we don't encourage. You want to do it as narrow as possible so that there'll be no ambiguity as to what you want to do. And obviously, a lot of early stage entrepreneur wants to hire advisor or startup board of advisors and so on. Be very clear as to what you want an advisor to do. You want an advisor to introduce you to 100 potential leads, potential customer, or attend at least 5 meetings a month, spend 2 hours every week and so on, doing helping you with your product and so on. So these are the things that it's important for you to put things writing so that everybody is clear in terms of the bandwidth and the resources that are being expected from each of them. So again, I've been talking about intellectual property for quite a bit now. Obviously, is a lot of things to look at, but obviously when it comes to IP, we are essentially looking at these several components, and obviously there are a lot more different intellectual property assets out there. You have geographical indication, you have trade secret, but essentially these are the four things that when it comes to play if you're a technology business. The usual thing I want to cover right now is obviously the copyright, which is where most of technology businesses own. They own the algorithm, they own the mobile application, they own the website, the SaaS platform. A lot of other things are usually more uncommon. Also trademark, also very important, which is the brand, the company name, the name of your app, for example, is something that you can trademark. Again, if you're an early stage entrepreneur, all this protection would cost a bit of money, which is why I really don't encourage you to spend all your hard-earned bootstrap, all hard-earned cash or bootstrap, since you're bootstrapping on all this filing at the moment. As you progress your business traction and maybe you have a money, that's why it may be good for you to hire an IP agent to help you with the necessary filing, because it can be quite substantial in terms of the amount that you need to spend. So very quickly, these are the checklist. Again, happy to share you the deck. Just drop me a note on my email. I'll share you shortly. I'll happy to send you the deck. So these are some of the things that you need to look at when it comes to IP asset, in terms of what are the things to look at to capture in your agreement. So the point I'm trying to make here is that if you are a technology company, doesn't people don't care that you have IP, so long as you can make money from it. And that's why it's important for you to be clear as to your revenue model. And your revenue model could through be the SaaS, which is a software as a service, as a subscription base. It could be a royalty payment in terms of a solution that you are selling to a vendor or a customer for that matter. And all these things needs to be captured in the agreement, which is why these are the things that the investors will look at when it comes to doing an audit or doing a verification as to what customers you have and what are the revenue that you're getting as a business or the tech company that you're operating. So again, if you're sharing your IP with a third party, be clear on the IP ownership issue. There might be, if you're in a collaboration, you're doing a partnership with another party, the other party may bring in the data or the customer's information, but you got the platform that could process the information. Be clear as to who owns the intellectual property that is created from that particular collaboration. And all these things can be captured in the agreement, which is why having an agreement will be a crucial component of your business transaction that you need to incorporate as part of your dealing. Again, I want to we have to end now. I think there are some questions already in the chat, which I'm very much looking forward to go through shortly. Why you need to have an agreement, obviously, is to deal with potential disputes and termination. See, there's several ways on how you want to administer your dispute. It could be arbitration, in terms of doing a more informal way of sorting out your dispute instead of going to the court, litigation, and for example. So in our experience, obviously litigation tend to be more straightforward, but again, some companies want to keep their disputes private, which is why arbitration is more discreet, in the sense that all the stuff that happen are not in public domain, because it doesn't form part of public document unless it's a court action. So again, we won't go through the details of serious clauses. What I'm trying to say here is that why you need to have things in writing. Obviously, you want to have finality in terms of the agreement that you've made. A lot of time, agreements or discussions are being done in Facebook messages, WhatsApp, so on. So having things in writing, it could be an email, it could be a term sheet, would really put a clear understanding or formal understanding as to what has been agreed by the parties. So again, we are about to end the next 3 to 5 minutes. I'm going to go through the Q&A shortly. Don't forget about the privacy and data protection, and obviously, depending on the country that you're operating, different country will have different sets of personal data protection laws. But generally speaking, you need to protect your customers' personal data. Obviously, when it comes to data collection, you should only get or collect the stuff that are important. Do you really need to know whether your client is married or not married? Do you really need to know whether they are their address and so on? So you need to make sure that you also get the consent from the customer. It can be a simple terms and condition. So even if you want to share the customer's data to a third party, you may want to anonymize it and make sure that you get necessary consent when the user sign up for third party or cross referral opportunity, for example. So very quickly on managing dispute, because I think it's something that I just wanted to highlight, because it's so part and parcel of why having an agreement is important. Um, Try your best to have things in writing. If you got into a call with a potential customer, you got into a call with a potential investor, try and send an email to summarize what you discussed. Hey, thank you for the meeting today. This is a short summary of what we spoke. We spoke about A, we spoke about C, we spoke about B, we spoke about C, we spoke about D. Please confirm if there's anything else that you want to add or comment on the summary of our call. So having things in writing really gives you a lot more clarity of thoughts in terms of what was discussed. It also acts as a precursor. It also helps a lot when it comes to drafting the contract later on, especially when the lawyer will want to know what are the commercial agreement was made. So obviously, please read the contract before you sign them. There's no such thing as a standard contract. Also important to train your staff in terms of managing customers' complaint and negative feedback, for example. And why you should have things writing is want to also make sure that things are organized. And how do you make things organized? Is having things in writing, and that's why having agreement is very important. And the last but not least is obviously to seek help as early as possible, and hopefully wait for problem to happen. Again, very quickly on managing dispute. First, don't panic. Don't go on social media and start writing a lengthy post about certain thing that happened. It's generally not a good idea. Keep all the documents in place, WhatsApp screenshot, email correspondence, any discussion that you have, and also chronology of events. It will really help a lot the lawyer that will be taking a look at your dispute in terms of advising you what are the likelihood of what will happen. Generally speaking, when it comes to a dispute, the judge will obviously not gonna have an idea of what actually happened. He will be guided by all the emails, all the correspondence, all the WhatsApp messages that were kept. So generally speaking, the party that kept all the messages will probably be the one that would have a stronger chance of actually succeeding. So that's something that would be a good thing for you to consider, why you should have things in writing and why agreement is so crucially important. So very quickly, summary before we go to the Q&A, contracts obviously are not the ultimate protection, whether you like it or not. There might be other issues that may arise even if the contract was signed, but having a contract can and will protect you from a lot of potential negative consequences. It also provides a proof that the parties agree on a particular term. If there's an investor that wants to invest in your company and you told the investor, like, we've got 100 customers, how do you going to prove to the investor that we've got 100 customers? You can say that, okay, these are the 100 contracts that were signed by 100 customers, or 100 letter of intent that the customer wants to sign up for our product. And that's why having contracts are very important. A lot of investors are investing in companies or other competitors wants to buy a smaller company or players because they have such good customers list, they have such good dealings with other vendors and so on. And that's why contracts should also form part of your important component of your entrepreneurial journey, because it's not something that you should be looking at as a secondary issue, because it's also very important from a value creation standpoint. And having contract will actually increase the value of the brand that you have as well when you protect your IP and so on. So obviously we want to avoid this thing called selective amnesia. See this happen all the time in the work that I do as an early stage lawyer that deals a lot with early stage entrepreneur. It becomes his word against your word, since nothing was done in writing. It's very hard for you to distinguish which one is the correct interpretation of the story. So having things in writing will avoid all this problem that his word against her word kind of situation. Again, you'll be wondering, like, I'm just a small company or a startup, who would care about all these things? The quick answer would be the fines or the cost of not doing it right is going to be a lot more. And obviously you may even lose your money because you don't put things in writing, things like the employment stuff that we mentioned to you earlier, why it's important to put things in writing when it comes to hiring somebody as a full-time or part-time and so on. And obviously as a founder you also become a director, and that's why you'll be liable to all this situation. I think the point that I wanted to make here, the last slide here, is that most of the time or all the time the issues ended up being discussed only when it comes to important times. So for example, there's a company bigger than your company wants to buy you up or wants to take over 100% of your equity. They will appoint lawyers to do an audit, and they look at your agreement, they are not in order, and an investor wants to invest in your company, and the more issues you have, the more business leverage that you gain away, and you may even suffer dilution or dilution of your valuation and so on. So that's something that you should take note. Again, thank you so much for listening. Happy to answer your question now. Yeah, there's several questions I'm going to go through now. I think Malik Amin is asking a question about technology device from Czech Republic to be used in Malaysia. Malik, I don't know what specific device that you're bringing. I don't know whether it's a medical device. My suggestion is, why don't you drop me a note and happy a separate chat in terms of how I can help you with that. To answer your question very quickly, if the technology or device does not belong to you and you are merely distributing it here in Malaysia, then you should have some form of distributor agreement and also a licensing agreement to allow you to help the owner of the device to sell it in Malaysia, either the manufacturer or the actual IP owner. So that's something for you to take note. So even if it doesn't belong to you, you should have the licensee right for you to be able to do so. So to answer your question, you don't need to get an IP for it, because the IP for it should be obtained by the owner of the intellectual property of the device. In this case, would be the Czech Republic company that has developed the technology of the device. So I hope that answers your question, Malik. Shermaine, you asked another question. Um, you're also a company secretary, so obviously a lot of company secretaries are having this discussion right now about whether or not electronic signature is allowed. But if you recall, in the new Companies Act 2016, the company's law allow directors and shareholders to receive notice for board meetings and shareholders meeting using electronic communication, which is the email. So obviously, if you want to sign using DocuSign and HelloSign, that's not going to be a problem. So obviously, when it comes to more complex documents like share transfer form, power of attorney, it will be an issue. So that's something for you to take note. So that's something else that we spoke about earlier. There are most of documents nowadays, like even normal contracts, can be signed electronically, so it's not a problem for you anymore. So again, thank you all for joining the session. I hope that has been useful. Again, happy to hear any specific question you have. Just feel free to drop me a note in my email. I'm happy to send you the copy of the deck, and happy to have a chat. And hopefully we can say hi again to each other soon. And thank you very much for listening.